You ever wonder what happens when a lawyer gets a piece of paper demanding they hand over a client's entire immigration file, and somewhere in that file is the name of a cousin still hiding out in a country where saying the wrong thing gets you disappeared? That is not a plot twist from a spy movie. That is a Tuesday for some immigration attorneys. A subpoena sounds scary because it has a fancy Latin name, but really it is just a court saying, "Give me that paper or explain why you will not." The problem is, asylum files are basically diaries of trauma. They include names, addresses, and sometimes photos of people who helped someone escape a government that does not forgive snitches. Here is the plain truth. Lawyers cannot just ignore a subpoena because they feel like it. That is how you get held in contempt, which is the legal version of getting sent to the principal's office, except the principal can lock you up. So the move is not defiance. The move is strategy, like a chess game where the queen is somebody's grandmother, back in a country you have never visited. Step 1 is almost always asking the court for a protective order, which basically tells the judge, "Yes, I will comply, but can we black out the parts that get people killed?" Judges are not monsters. Most of them understand that a source's safety matters just as much as discovery deadlines. Attorneys also lean on something called in-camera review, which sounds like a spy gadget but is really just the judge reading the sensitive stuff alone in chambers instead of blasting it into open court. Think of it like showing your diary to one trusted teacher instead of reading it out loud in front of the whole class. There's also redaction, the legal version of a censorship bar on reality TV, where names and identifying details get blacked out while the rest of the story stays intact. It sounds simple, but doing it wrong can accidentally reveal someone anyway, so lawyers spend hours making sure a redacted document is not a jigsaw puzzle with the last piece basically shouting the answer. A lot of people confuse subpoenas with warrants. And honestly, it is an easy mistake. But they are cousins, not twins. A subpoena says produce documents or testify. A warrant says we are coming in whether you like it or not. And knowing the difference changes the whole game plan. Attorney-client privilege gets tossed around like a magic shield, but it has limits. It protects legal advice, not necessarily every fact a client shared. That is why smart lawyers separate their notes into what is privileged commentary versus what is raw factual history, because the courts do not always buy, "Trust me, all of it is secret." Sometimes lawyers argue for a complete quash of the subpoena, which is a fancy way of saying, "Nah, this request is too broad, too dangerous, or too irrelevant. Throw it out." Courts actually grant these more often than people expect, especially when national security or asylum protections from places like the 1951 Refugee Convention get name-dropped. Here's a twist people do not see coming. Sometimes the danger is not the courtroom. It is the paperwork sitting in an email inbox waiting to get hacked. Cybersecurity for law firms is now just as important as legal strategy, because a subpoena fight means nothing if a hacker leaks the file before the judge even rules. There's also the option of anonymizing witnesses using pseudonyms like Witness A or Source 2, basically giving real people spy code names straight out of a heist movie. It protects identity while still letting the legal process move forward, which is a nice middle ground between silence and exposure. International cases get spicier because you might be dealing with foreign privacy laws too. So a document might be legal to share in one country and a jailable offense in another. Immigration lawyers sometimes end up needing an international law consultant just to make sure they are not accidentally starting a diplomatic incident over a PDF. Preparation is the boring secret weapon here. Lawyers who build in safety protocols before a subpoena even shows up are way less likely to panic when one lands on their desk. It is kind of like wearing a seatbelt before the car crash instead of trying to invent one mid-crash. The honest lesson in all of this is that the law protects people, but only if someone fights to make it protect the right people at the right moment. It is not about hiding from the system. It is about using the system's own tools, protective orders, redactions, in-camera reviews, to keep both justice and human lives intact. So, if you found this wild, and you want to actually see how real immigration and legal professionals handle situations like this every day, do you want to learn more about our company? Check out our links in the description.